Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. In a significant intervention in violence at Manipur on the eve of no confidence motion debate in Lok Sabha, where the opposition was expected to corner the government over the situation in the state, the Supreme Court has said that it is appointing former Mumbai Commissioner Dattatreya Padsaglekar to be the overall monitor of a CBI probe into the instances of sexual violence in Manipur. In a significant development, the Supreme Court engaged in a thoughtful evaluation of the abrogation of Article 370, which granted special status to the erstwhile state of Jammu and Kashmir. A five-judge constitution bench led by Chief Justice of India CJI Chandrachud dwelled into the complex matter, shedding light on the intricate constitutional aspects surrounding the abrogation. The bench acknowledged that while it might be challenging to definitely assert that Article 370 could never be abrogated, the crux of the issue was to determine whether the process followed in the abrogation was legally sound. Every accused has a constitutional right to be reintegrated into the society, the Supreme Court has said while hearing the petition challenging the remission granted to the Bilkis Bano case convicts. Justice B.V. Nagaratna, presiding over a two-judge bench, made the remarks as a counsel appearing for the public interest litigation petitioner contended that there can be no fundamental right to remission. The Supreme Court has underscored the responsibility of high courts to consider not only the contents of an FIR but also broader context and material gathered during investigations when dealing with petitions seeking the quashing of criminal proceedings. The court emphasized that particularly in frivolous or vexatious cases, the judiciary should delve into additional factors emerging from the case record and adopt a circumspect approach to extract definitions. The Supreme Court has recently provided clarity on the application of the principle of res judicata in subsequent proceedings. The court held that only fundamental determinations made by the court would be subject to the principle of res judicata, while collateral observations that are not essential to the final decision would not be bound by it. A bench comprising of Justice Surya Kant and Justice J.K. Maheshwari laid down the principle while adjudicating an appeal in the case of Yadiha and another versus the state of Telangana and others. The case involved an intra-court appeal by the state of Telangana and its revenue authorities, which was allowed by the reversing the decision of a single-judge bench. Now let's get an overview of high courts. The Delhi High Court has issued a permanent injunction against an individual, Mr. Vinay Kumar Singh, restraining him from utilizing the trademark Whitehat SR on any other name that closely resembles the registered mark Whitehat Jr. This ruling comes in a response to a lawsuit filed by Whitehat Education Technology Private Limited, an edutech startup known for teaching coding to children through its online platform. A division bench of the Bombay High Court comprising of Justice Vibha Kankanwadi and Justice Abhay S. Vagwase held that under Section 149 of the Indian Penal Code, liability extends to every member of an unlawful assembly who shares the common object even if they did not personally commit an overt act. The court upheld the conviction, stating that the gathering of the accused was with a common intention and each of the appellant had a definite role in the assault. The division bench of the Jharkhand High Court set aside the termination order of a junior engineer and held that after setting aside the order of termination from service, the government employee shall be reinstated in services and put under suspension to hold the departmental inquiry, and only a government employee who is in service can be put under suspension, and it is only in case where the termination from service order is quashed after the delinquent government employee had attained the age of superannuation that the employee is deemed in service to conduct the departmental inquiry against him. The Jharkhand High Court dismissed a petition raising objection to the execution of an arbitral award under Section 47 of the Civil Procedure Code and held that the party cannot be permitted to object to its execution by alleging that it to be nullity or without jurisdiction unless the award suffers from an inherent lack of jurisdiction apparent on the face of the record and the jurisdiction error goes to the root of the matter and is apparent on the face of the record, and the moment such plea of nullity requires deliberation on fact and law, such objection is not permissible at the stage of execution of the award. In a recent development, the Delhi High Court has expressed its disapproval of the family courts granting very long adjournments while referring parties to counselling for matrimonial disputes. Justice Naveen Chawla highlighted the importance of timely resolution and supervision of counselling proceedings before counsellors. The Bombay High Court has recently addressed the responsibilities of an employer in case of accidental death or injury, specifically in the context of a contractor's employee. The court ruled that the principal employer's liability is limited to providing compensation as specified in Section 12 of the Employee Compensation Act. It clarified that any penalty or interest or default is not part of the principal employer's liability in such cases. The Delhi High Court has held that a mere acquittal does not automatically entitle an employee to reinstatement in services. It must be an honourable acquittal. The division bench, comprising of Justice V. Kameshwar Rao and Justice Anup Kumar Mendirata, noted that expressions like honourable acquittal, acquitted of blame, or fully exonerated are not defined in the Code of Criminal Procedure or the Indian Penal Code. They have been coined through judicial pronouncements. However, when an accused is acquitted after a thorough consideration of prosecution evidence and it is evident that the prosecution failed to prove the charges against the accused, it can be deemed an honourable acquittal, the court noted. Moving on to international news this week. In a landmark decision, Nepal's Supreme Court has paved the way for an investigation into a major land scam that implicates former Prime Ministers Madhav Kumar Nepal and Baburam Bhattarai. The court ruling asserts that those responsible for policy decision regarding the transfer of Lalita Niwas land plots to private individuals should not escape scrutiny. A court in Australia's Queensland state has overturned a law that banned Sikh students from wearing a kirpan, a religious article in Sikhism, on campus, calling the legislation unconstitutional. The ruling by the state's highest court came after Kamaljeet Kaur Athwal took the state government to court last year, claiming that the ban discriminated against the kirpan, one of the 5 religious symbols that Sikhs are supposed to carry at all times as part of their faith. The National Company Law Tribunal delivered a monumental verdict on Thursday, granting its formal no to the eagerly anticipated merger proposal between Zee Entertainment Enterprises Limited and Culver Max Entertainment, formerly known as Sony Pictures Networks India. This pivotal regulatory approval marks a significant stride towards the creation of a colossal $10 billion media conglomerate, a merger that was announced in 2021 but confronted numerous delays due to various complications. A recent judgment by a consumer court in Gujarat has brought significant relief to consumers who order from fast food chains KFC and Pizza Hut through the food delivery app Zomato. The court ruled that these restaurants cannot impose additional fees for packaging on their customers. The decision follows a public interest litigation filed by Ronak Sinha, a 21-year-old law student from Bihar, who noticed the extra charges while placing an order on Zomato for himself. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.